Good morning or good afternoon, depending on where you're joining us today. My name is Chelsea Domenico, and on behalf of Ethisphere and our partners at Baker McKenzie, I'm pleased to welcome you to our webcast on the CCPA journey, Readiness for Compliance, Data Privacy Controls, and the GDPR comparisons. Over the next hour, you'll hear from experts at Baker McKenzie, ARM, and Pacific Life Insurance Company as they dive into insights on some of the current company practices, anticipated hurdles pre and post CCPA enactment, comparative takeaways from GDPR activities, and enforcement considerations to better prepare the company for this newest piece of the growing data privacy puzzle. If you've ever joined us for an Ethisphere webcast before, you know that we love to take your questions throughout today's session. Please use the chat box feature you see within your webcasting platform. Our goal for every webcast is to encourage you to ask as many questions as you may have, and we are anticipating a handful of questions on today's topic, so we'll try to answer as many as we can. However, if we do run out of time, we will follow up with you via email. Following the live webcast today, you will receive an email from us, including this recording of today's webcast, as well as the PowerPoint presentation. Our Bella members will also have direct access to these materials on the Bella Member Hub. I'll quickly introduce our speakers as you see on your screen here before turning today's session over to Brian. We have Brian Hedgesbaugh, Partner and Chair of Global Data Privacy and Security Business Unit at Baker McKenzie. Laura Bleesner, Senior Counsel, Data Protection and Privacy at ARM, as well as Patricia Thompson, Assistant Vice President, Deputy Chief Compliance Officer at Pacific Life Insurance Company. With all that said, I hope your questions are ready, and I'll turn the floor over to Brian.
Perfect. Thanks so much, Chelsea. Great to be with you all. Kevin, maybe if you would advance to the slide number 5, that's the overview. So we're here to talk about the California Consumer Privacy Act, and if those of you who are participating with us had any experience with the European Union General Data Protection Regulation, you're familiar with the type of privacy regulation that is CCPA, which is a comprehensive consumer privacy rights law, and it's really the first of its type on the shores here in the United States. Europe has done this type of comprehensive or omnibus privacy law for many years, going back to the 1995 Data Protection Directive, and actually even earlier than that, many of the member states had their own sort of comprehensive laws. It becomes operative on January 1, 2020. We'll talk about enforcement in a little bit, but the operative date is coming right up upon us on January 1. One of the key hallmarks of this type of comprehensive legislation is that it creates an expansive definition of personal information. So here in the States, we're very familiar with HIPAA in the healthcare space, or GLBA in the financial services space, privacy laws that have particular industry focuses, a particular lens. Well, this is really an expansive definition of personal information, which applies across industry sectors to start with. There are some carve-outs, but it's really any time an organization deals with information about an individual who is a resident of California. So very broad scope. And we're going to talk about some of the amendments, too, that just came down on Friday, which impact how personal information is going to be applied right out of the box. But that's the concept starting point. Anytime we touch as an organization data about an individual, we're going to have to deal with some privacy right issues in California. What's the substance? Well, there's new privacy rights for California consumers, meaning individuals, including rights of access. So think somebody can come to me and say, I want a copy of all the information that you have about me. Deletion, there's a little bit narrower rights, but rights to instruct the company to delete data about the individual in certain cases. A right to opt out of the sale of personal information, which is a significant issue from a planning perspective. And a lot of times people hear sale of information, they think, well, my company doesn't sell information. Well, just wait, let's talk about how it's defined and how broadly it's defined and where it may come in. If you deal with minors in your business, there's actually not opt-out but opt-in for the sale of minors' information, and certain non-discrimination provisions when these rights are exercised. And I will say that if you did have experience dealing with GDPR, I like to say that I think CCPA makes GDPR look like a work of art and a model of perfection and clarity and ease of understanding compared to the way CCPA has come together. So, and I say that in light of the non-discrimination obligations, which start with saying you can't discriminate against anybody on the basis of them exercising some rights, but then ends up giving back a whole bunch of that, including an ability to offer financial incentives. So it gets murky as to how to really interpret some of these provisions, which I think leads to some real complexity when you're trying to do the compliance activities. CCPA applies to companies worldwide, including business to consumer and business to business companies. Again, there's some carve-outs which we're going to talk about and some changes, particularly in the amendments we just saw on Friday. But that's the starting point. You know, the name is somewhat of a misnomer, California Consumer Privacy Act, because of how consumers define broadly as any individual. Probably the scariest part. So with CCPA, there's a tremendous amount of work, and both Patricia and Lara are going to be talking to us about what they're actually doing in their programs in just a few minutes. But the scariest part to me as external counsel are these new statutory damages in the case of data security breaches. So quite apart from all the substantive rules we just sort of quickly summarized right there, there's going to be a private right of action plus a statutory damage provision, so that if you have a data breach of credit card numbers, social security numbers, or other sensitive data, passwords, PINs, etc., in principle, come January 1, the plaintiff's bar will be able to bring not only a private right of action against that incident for not having reasonable security, but also get statutory damages of up to $750 per individual per event. So if we have an event that loses data about 1 million people in California, I'm a lawyer, I don't do math well, but 750 times a million, $750 million worth of statutory damages right out of the box before you even get to attorney's fees. And so even though there's no new substantive requirements around necessarily the reasonable security standard that's embedded in California law, a lot of companies are looking very carefully at doing a refresh on how they protect the security of sensitive personal information, simply because we know that there's going to be some private actions coming. And overall, the one big picture comment I have is CCPA is a very complex law. It's complex because of how it's drafted, which is not the best drafting in the world. It's complex because of the drafting. It's complex because of the understanding of how it relates to other laws that are already in the books at the state and federal level. But it also really has a significant impact for business units, for information technology and security, compliance, legal, human resources, and other business and operational functions. And so one thing that I would say would be a mistake would be just to think that this is a privacy office issue, or this is something for the legal department to look at. If that's the way the organization is approaching it, you're probably not going to get to the type of compliance you really need to get to in order to have assurance that you're doing it right, because there's just too much operational impact to it. So maybe hop to the next slide, if you would, Kevin. And I'm just going to give you, I mentioned, by the way, on Friday, there were a number of amendments being considered to CCPA, and the legislative session ended on Friday, and a number of them were adopted. Some of them were set aside till later. The governor has another month to actually sign those amendments as they came in, and then we're also waiting on regulations from the Attorney General. So I'd like to say that we're trying to kick a field goal here as the goalposts are moving around on us on this, right? So there's still, we still need to see if the governor signs this. Also, we're still waiting for regulations, but nevertheless, this is the environment we're operating in. And what I did here on the slide is just one of the amendments tweaked how personal information is defined, not really hugely materially, but nevertheless. So personal information, I said it's a broad term. It's any information that identifies, relates to, or describes, or is now red bracket reasonably, that was one of the amendments, but reasonably capable of being associated with, or could reasonably be linked with a consumer, which is again any individual who's a resident of California, or a household. So this is a new innovation in privacy law around the world. We've not had this before, where personal information can be tied to a household. It has a number of implications for loyalty programs, for connected devices in the home. There's a whole range of applications for it, and I think it causes quite a few challenges as you're trying to get to compliance. But so we have in the hexagons here below identifiers, protected classifications, meaning sensitive information, browser search data, geolocation data, audiovisual, et cetera, employment information, consumer preferences, and commercial information. So there's a whole bunch of information. It's really any information about an individual or device, ultimately, that is starting point within the definition of personal information. Note here at the bottom, certain industry-specific types of data are not covered by CCPA. So if you're in a regulated industry where maybe you're a HIPAA-covered entity or a business associate, there's certain carve-outs for you that can come into play that you'd want to look at. So there's quite a bit of complexity, the interrelationship between the federal rules and the state laws. Interestingly, for example, you might be an entity that's covered by the financial privacy regulations under the Gramm-Leach-Bliley Act, but then you have to kind of think broadly and say, okay, but not everything we touch as a financial institution actually is limited to what's covered by GLBA. So to the extent we have B2B customers, or to the extent that we have, websites or other properties where we're gathering data before we formed a consumer relationship, we may still have some exposure to CCPA. Okay, next slide, if you would. So probably some of the biggest changes here in terms of the legislation that was just adopted on Friday and still awaiting the governor's signature is one of the big changes. Again, the basic definition, consumer means residents of California, including consumers, end users, and even employees and individual representatives of corporate customers. When it comes to the employee data, so the internal human resource data, the amendment essentially said you get one more year beyond January 1, 2020 to get your house in order on the human resources data, with the exception that we still want you to give a sufficient privacy notice under CCPA to the employees. So good news and bad news. Good news is, a lot of the access, deletion, opt-out for sale, et cetera, that doesn't come into play yet for human resources data, but we still have to deliver a notice, and we may want to leverage, say, our GDPR notice to help with that type of situation. Another one that was sort of a later breaking but still helpful carve out was individual representatives of corporate customers. So this is, think B2B context here. There's the words, again, are not a model of clarity, so you have to kind of read it closely, but essentially we'd read it to say that you get a 1-year delay with respect to data that you have from transactions and communications in the context of transactions with B2B customers, except for the sale. The sale provision, the rights to opt out of sale, are still going to apply. So what does that mean in practice? Well, if you have, say, online behavioral advertising, you're doing retargeting, you're sharing data with ad networks, you're going to have to look closely at that, because that may indeed be a sale of some of that information that requires the provision of opt-out. I mean, the good news I would say there is that there's a lot of mechanisms in place for that kind of online advertising ecosystem to get opt-out rights available to people, but nevertheless, that's still an area you're going to have to take a close look. I would also say, if you happen to be doing things like purchasing marketing lists and other things where you're not really working from an existing transaction or relationship, you may still have to do some work on B2B. So that's a quick summary. Those are some of the key, I think, potential definitional changes and scope changes that have been late breaking, which I think will be helpful for people. So, and then here's down below, you get a more precise bullet of who's actually a resident, and then there's certain thresholds you have to meet to come within scope in terms of you're doing business in California, you have gross revenues in excess of 25 million, PI of at least 50,000, or derive 50% or more of your annual revenues from selling. A lot of companies end up getting caught by that first bullet anyway. They're doing business in California, and they have gross revenues in excess of 25 million. I'll just touch on, because we're doing just a quick look through these issues, I think one of the real complex issues is what happens within the intra-group context with this. So there's, again, a definition of business that, in my view, is not well drafted. There's kind of two parts to business. One is what you see on the screen here, which is that you do business in California and you meet one of these 3 bullets of 25 million. The next bullet down, and there's no conjunction between these paragraphs, so you hear the lawyer and me talking. There's no conjunction, there's no and or the word or we don't know how these two paragraphs are related. But then the second paragraph goes on to say, any entity that controls or is controlled by a business under paragraph 1 and that shares common branding. And so then you're left with asking the question, well, what does that mean exactly? Does that mean if I'm an entity that is owned by a parent and I have the same branding and I'm otherwise not triggering these thresholds, am I part of the same business as the parent company? Am I a separate business, but I'm just pulled in because this is a broader grab for jurisdiction over other companies? There's a fair amount of ambiguity as to what the exact scope or benefit there is to being part of having common branding and being controlled or controlled by. The other bit that I would say that's complex is what do you do with sister companies? So the exact language in that second paragraph refers to really vertical arrangements as opposed to horizontal sharing between among sister companies. So plenty of ambiguity. And in theory, the benefit would be if we are part of the same group that shares common branding, in theory, any sharing of data between and among us would not be a sale that would attract opt-out rights. That would be the theory. But a lot of that comes to how you interpret it. Okay, so on to the next slide. I'm just going to briefly touch on these and then hand it over to Patricia to talk about Pacific Life and how they're tackling these issues. But the right of access, the idea is somebody, an individual can come to you and say they want access to their data. You're supposed to comply within 45 days of receiving a verifiable consumer request, which is itself its own subworld of how do we verify the identity of the person asking us the question, which I think is in my view that's a bit of a security question more than a privacy question in a sense, because you need to think about the sensitivity of the information they would get. You need to think about what's reasonable to authenticate their identity in this kind of context. And you're just supposed to disclose all relevant information with a 12-month look back. So, and here's the types of information covered. So, one of the concerns we've seen emerge from GDPR is that individuals are using these privacy access rights as a form of pre-litigation discovery because there's not a lot of exceptions built in to when access is provided, and that's something we're just going to have to watch and see how it develops. Next slide, if you would. Deletion. This one is a bit scarier because in principle, you are supposed to delete the data when the individual comes to you. Now, the good news here is there's a number of exceptions to deletion if you need the data to complete a transaction, to comply with the legal obligation, and perform other specified purposes. So there's some exceptions to this, but nevertheless, really the company is going to have to, this is a great illustration of where this can't just be a privacy office exercise or a legal department exercise, because they won't know the systems, they won't know the data, they won't necessarily know the purposes, and they certainly won't know how to delete information, right? Because there's oftentimes a lot of complexity if you're looking at a database environment. Okay, if we delete that data, we're going to break the database. So how are we really going to achieve this? So there's a fair amount of work you can see flowing from that work stream. Maybe hit the next slide. Right to opt out of sale. So again, sale, this is a very broad definition, and if you're a lawyer, you might remember back to first year contracts class being called on by your professor to explain what consideration is, right? And consideration can be anything. It can be a peppercorn, any inducement, et cetera. And so the challenge is, okay, we might be sharing data with a vendor, and that data might be taking the data and using it for its own analytics or secondary purposes. And that's part of the inducement for them to enter into the contract, because they then, do this analysis across all of their customer base, and they have maybe interesting or unique products they offer back to the market and things like that. Well, because of how broadly this is written, sale is any selling, et cetera, to another business or third party for monetary or other valuable consideration, it looks like we might be dealing with the sale in that kind of vendor environment. And I should also say there's, of course, a risk analysis that goes into all of this. Obviously, if you're selling a marketing list, that's a different risk profile for this purpose than if there is a vendor who's doing analytics with no impact on the individual, but nevertheless, those are the definitions we've been given. Maybe hit the next slide. This is its own little set of issues then to work through, which is you have to look at all the sharing and figure out, okay, what is a sale, or more importantly, what's not a sale? And it's not a sale if the disclosure is done at the consumer's direction, if it's just to alert the third party that the consumer has submitted an opt-out request. Interestingly enough, you're not obligated to do that, but nevertheless, you could tell recipients that the consumer had opted out. If it's part of a merger, or maybe the last one that's most significant, if it's to a service provider. A service provider is defined as someone who only performs services on behalf of the business and does not further collect, sell, or use the personal information. So you really would be locking them down. There's also some benefit if you get a certification from them that they know they're not going to use or disclose the data except as to provide the services, et cetera. If you get a certification from them, then you get some protection from liability. There's actually a liability shield written into this, as long as you don't know or have reason to know that they've misused the information. So that tends to drive you into a contracting exercise. And maybe hit to the last slide, if you would. The last slide, or a couple slides here. Anyway, notice, yeah, thanks, Kevin. Notice here's the content that essentially you're going to be wanting to update your notice to include. A big question people often have here is, am I just going to mark up my existing privacy statements that I use and add some content, or am I going to create a separate section for California residents? There's a related question here as to whether you're going to offer these rights to just California residents or whether you're going to offer them to everyone in the U.S., knowing that there's a whole bunch of states in the wings that are probably going to be adopting similar laws, much like everybody did with data breach after California adopted it. So there's some strategic decisions, but that's your sense of the content. And then maybe hit the next slide. So one of the big issues is if you do sell information, so maybe let's take a simple example. Let's say you are doing sharing of data, or you're allowing third-party advertising networks to drop cookies, pixels, et cetera, on your users' devices when they visit your site, and you say, yeah, I think the better read of all this is I do think there's data that's being shared with those advertising networks for consideration. So therefore, and maybe there's a couple other instances across the business where you are engaging in a sale and you need to provide opt-out rights. Well, one thing you need to do is put a website link that says, do not sell my personal information on the web page. Every web page, it's actually part of the joy, right? It's defined as you have to put it on the home page, but then home page is defined as any information collection point. So really you're talking about adding another link to the bottom of your website statements, which says, do not sell my personal information. I personally think that, I think there's a fair amount of, at least, certainly when this first came out, there was a lot of concern about what does that do to our brand if we put do not sell my personal information on the page. I think if you do some, and I think the market, this is part of the joy, I don't think the market has really settled out yet as to how often people are actually going to be putting this link and who are going to be offering these choices. My personal view is, having seen for years, links being put at the bottom of websites and things like that, I'm not really sure that people, we did it with your California privacy rights, you've got a privacy policy. I'm not sure how much brand impact this really will have. And I'm also not sure whether most of the market isn't going to feel like, we all do online behavioral advertising, so we're going to go there. So it's difficult to know with certainty. I think these are all, though, critical questions to discuss within the business, within the environment, knowing your customer base, et cetera. Okay, next slide. And sanctions. So ultimately, this is supposed to be primarily enforced by the California Attorney General. There's actually a 30-day cure period, which is, so imagine what we get a notice from the California Attorney General. They're concerned about our selling of data. They come in and they do an audit, and gee, lo and behold, we are doing some selling. We didn't realize that, because of the third-party relationships we have, and we're working on narrowing it. In theory, you get a 30-day period to cure before any fines are imposed. The fines in the grand scheme of things don't look huge, but then a question is, what's a violation? Is $2,500 per violation, meaning per individual, or is it, per actual incident itself, in the aggregate? So anyway, but this next one is the one that I worry about the most, the private right of action. As I said, if you look down, if it's a data breach, meaning social security numbers, credit card numbers, health information, passwords, et cetera, You're looking at statutory damages up to $750 per incident per individual, which can get quite high. And then also, we've already heard that the plaintiff's bar is sharpening its knives on this one to take the position that even though there's some language which is intended to protect against it, that any violation of CCPA, they may bring an unfair competition claim and assert that noncompliance with CCPA or any other law is the basis on which they take that action. So, so there's some lack of clarity about how the rules are written on this, but we're certainly concerned that there's a possibility that the plaintiff's bar will think more expansively about going after not just data breaches but others. So that's a very quick summary of where we're at with CCPA, and maybe I'll hand it over to Patricia now to talk about the Pacific Life experience.
Thank you, Brian. That was a great summary, and I was actually taking notes as you were going through this on some things that are still outstanding questions in our compliance program and implementation strategy here at Pacific Life. So just by way of introduction a little bit, we are a life insurance company. We've been in business for over 150 years now, and obviously because of the type of business that we do, we have a variety of sensitive data elements that fall within CCPA, including health information, biological information, financial information, and then also personal preferences and characteristics. So we have data that could fall into any of the categories that Brian showed us on that slide in terms of covered by CCPA. We are also, because we're a financial institution, we are covered by the GLBA information exemption that is available in CCPA. However, like Brian alluded to, it's not 100% exemption because it's not an entity level exemption, and we know that there are pieces of information that we may have collected over the years that are not strictly pursuant to GLBA. Or there are categories of individuals who we do business with that are not strictly pursuant to GLBA. We are not viewing that as a perfect exemption that just carves us out of CCPA compliance. Having said that, the other part of this for us from a practical perspective has been that we view CCPA not in isolation, but obviously within the context of the global privacy space, as well as what we see happening here in the United States. And since consumers and regulators alike are having greater expectations about how they interact with businesses and how businesses take, use, and share their personal information, when CCPA came out last year, we went to senior leaders within our organization and said, we have two paths available to us here. One is to take a narrow view of CCPA and try to take advantage of all of the exemptions available and really kind of narrowly comply. Or we could take a broader view and say, this is a train that it has either left the station or is close to leaving the station, and maybe we should view CCPA as an opportunity to look at how we have data, how it moves across our organization, how we use it, how we retain it, and then how we interact with consumers about the information that we have, and other businesses as well. Fortunately, we were able to get the buy-in for the latter approach, and so we have taken kind of what I would describe as a required compliance plus voluntary compliance with the CCPA language and its principles in terms of building our compliance program out here at Pacific Life. So what you're seeing there on the screen is just a really high-level overview of how we have structured our implementation project here. I should also note that our core business is domestic United States, and so we did not go through an entire GDPR compliance exercise for our entire entity. We did for some of our subsidiaries, but for our core Pacific Life business, we did not. So we were a little bit maybe behind some other companies who are doing a more global-based business in terms of having a full data inventory mapped out. And so really that's where we started. So we really started to look at this and say, what are all of the data elements that are included, and how do we find them? Where do we know they live and sit within our systems? Who is responsible for owning those pieces of data, and who touches it and for what reasons throughout the organization? And how long do they need it for? And and what would it look like if we were to ask them to anonymize it or to de-identify it in a way, or just to delete it entirely off of their systems? So we set up a structure and a framework with a variety of committees that have a varying number of members. And what I would say is this adds up to 110 members, but there's a lot of duplication here. So in terms of, we don't really have 110 people working full-time on CCPA compliance. That would be completely misleading. In fact, I would say we probably have a total of 3 employees who this is a full-time role for them right now, and then other members kind of come in and out and touch a variety of different parts of the project as we have moved forward and get closer to implementation date. The other thing about Pacific Life and our implementation project that is both helpful because we're sharing the workload, but also a little bit of a challenge, is that we have a decentralized structure. So we have a corporate compliance department, we have a corporate privacy office, we have corporate legal, and corporate IT departments, but we have divisions and subsidiaries that also have their own compliance departments that's more specific to their business. They have their own tech specialists, they have their own operational areas, and they have their own systems. And so when we're thinking about, and when we were going through this process of trying to figure out how we would comply with CCPA, particularly within the abbreviated time frame that we're going to have to search, find information, produce information, and then potentially delete information, or at least de-identify it, we really looked across the organization and said, we don't have a transparent one-stop shop where we can kind of centralize this entire CCPA function and say, you know, this core team of 2 people or 3 people are responsible for responding to a CCPA request and all that goes with that. So we've really had to build in an infrastructure throughout the enterprise that allows for the flexibility to be able to have a central location for consumers to come and ask about the information that we have, and for us to interface with consumers in that way. But that really kind of fans out across the organization to be searching for all that we may or may not have.
Hey, Patricia, you're doing great, and I can't resist but ask you a question. Did you consider an alternative structure there where you'd have each business area responsible for responding, you know, to the individuals within the business area, as opposed to an enterprise-wide solution for that? And how did that consideration go? And I mean, I like the one-stop shop, but I'm just wondering how that discussion went.
Yeah, that's a great question, and historically that is right in line with our culture and with how we typically implement regulations, is that we ask the businesses that are closer to the information and closer to the impact to be managing to the compliance. So we did look at that. There were a couple of pitfalls that we thought were challenging in that approach. Some of them being efficiencies and a lot of duplication. But then also we were concerned about the confusion, both at the regulator level as well as at the consumer level, and then also looking at this potential of a plaintiff's bar and what our public face looks like in all of those contexts, to say that consumers don't view us as a conglomerate of 5 or 6 companies. They view us as Pacific Life. And so if we had multiple touch points that were not coordinating responses and talking back to consumers from a holistic enterprise perspective, we ran the risk of both misleading consumers and providing incomplete or inaccurate information in our responses, particularly in light of the idea that that information very easily can move from one area of the company to another, and in the deletion decisions and categorization in particular, not just the production of information. We wanted to make sure we were doing really holistic approaches to say, if we're going to represent to a consumer that we're deleting their information, that we're actually deleting their information across the enterprise and not just within one division or within one system.
Got it. Great.
A lot of the things that we've been challenged with along the way in real life have to do with some of the uncertainties about like the fact that we've been in this constant state of flux about what does AG guidance look like. And what if we make a decision to operationalize in a way that comes down, that's inconsistent with what the Attorney General eventually provides to us, like the question of what is a verifiable consumer request? What information can you ask a consumer in order to verify their information? Things like that. Being in financial services, we also viewed this as a security question, really at its core. And so we've kind of taken that position to say, what are the questions that we think would be most meaningful in terms of both being responsive to consumers, not overly imposing, but also meeting our responsibilities to keep their information private, which we view as really being at the core of any business that we do with our consumers. They've entrusted us with the information that we have in order to provide them with a service that they want from us, and so at its core, we need to make sure that we're protecting that from potential wrongdoers and those who would be using the information for evil instead of for good. So we've really taken the approach in that exercise, even in the absence of AG guidance, to say, what do we currently do to verify consumers' requests when they come in and ask for information about their contract or ask for information on transactions, whatnot, and then how do we translate that into a broader public interface where we say these are the core elements that we need to identify you and know that you are who you say you are before we start just sharing a wide variety of information with you. The other area that has been a particular
I can't help it. I was trying to hold myself back. I can't do it. Anyway, so I was going to say the other, because I think organizations really struggle with this one, right? And you're right. I mean, we're waiting for AG guidance, but we also don't want to create a data security event for ourselves by not having strong enough authentication controls. So I think if people do think about this one, like you were thinking, in terms of what's our regular, ordinary course of business dealing with these particular individuals, what data elements in there can we use to help authenticate? I see a lot of times people using an email account on file as a way to authenticate identity, or at least a factor. If it's really sensitive data, maybe we go to asking data points like the credit reporting agencies often do, asking things that only this data subject might know about transaction history with us or otherwise. But I think it's one that I'd like very much the idea of looking at it through a security lens and what's reasonable and appropriate, given the sensitivity of data. So, and I ultimately think I can't believe, given the complexity of all the different industries and all the different relationships, it's difficult for me to expect that the AG is going to come down with much of anything that isn't essentially a principle-based security set of standards that need to be followed, as opposed to something prescriptive. So that's my hunch. But anyway.
We are super hopeful that you're right on that, because right. Having to pivot this late in the game will be challenging. But it was, again, one of the things, and really from a governance perspective and getting the buy-in across the organization, as I'm sure many of you in the audience have dealt with or are dealing with in these large compliance projects. I can't overemphasize how important regular communication has been for us. And so we've been having conversations at all levels of our organization to be able to say, what does this look like in real life for customer service? And if you get a request like this, if you get a phone call, if you have to respond in real time to a consumer request, what does that look like, and what is the impact on the job and the core function of what we have asked you to do for our company? And then taking that information and pulling it all the way up through conversations with team leaders and division leaders and our senior management as we're trying to make these decisions and have them be principles-based, so that ultimately we feel good about the idea that CCPA or no CCPA or North Dakota or Washington or GDPR or Nevada or any other state or a federal law should we get there, that we feel good about the decisions that we've made about how we are treating our consumers, and that hopefully they feel good about their interactions with us. They continue to trust us, and at the end of the day, hopefully, that may be the best defense against a private right of action, is that if you don't have disgruntled consumers, that goes a long way toward not having at least individual private rights of actions brought against you, whether that's a defense against class action lawsuits or not, or could be debated in another webinar. But I think we've really tried to keep that at the core of our decisions all along the way. So whenever we get to a sticking point and say, we're not sure what to do here because we think the AG is going to come out with guidance, the law is unclear, and we're not quite sure which way to go, one of our core questions for our team has been, if I were a consumer of Pacific Life, what would I want this to look like? And so we're in California too, so a large group of our employees sit here in California and are also beneficiaries of this law. And so a lot of the things we've also been challenging each other with to come back is to say, how do we expect that we as consumers will interface with other businesses that we interact with, and what will that look like? And so having that sort of help guide us along the way in terms of these implementation decisions has been useful. And then also taking that broader approach to saying CCPA probably is not the last of these laws that we will have to comply with, and whether hopefully we'll get uniformity out of other states or out of a federal bill at some point. But the more flexibility we can build into this, we think the better off our consumers and our business will be along the way. I'll pause there and ask if there are any other questions, or Brian, if we're ready to move to Laura, that's great too.
Yeah, no, I was just going to two things. One, note that you had great success from the outset in terms of getting the attention of senior management and getting them to take sort of a broader view on thinking about this from the consumer perspective, and what do your people, your constituents, what would benefit them, what would they appreciate, what would they expect. I think that probably will carry you past a lot of otherwise pretty complex legal decisions on particular exceptions and things like that, how do they actually apply, and move you past a lot of risk decisions. I know not everybody has that success on that point. In fact, I was thinking about asking you if indeed you could comment for a moment on how you managed to get senior leadership to buy in. Was there any particular tricks? Because I know that's not the case for everybody. Sometimes people have difficulty. Like, how did you actually get there, or was it easy?
It's a great question. I wouldn't go so far as easy. I would say it involved a lot of conversations with a lot of individual leaders along the way, to kind of say, what does this look like to you? Does it make sense? What are the types of things that you would like to see as side benefits coming out of this project if we undertake this broad scope approach to implementation? What information might you as a business get out of the work that we're doing here that serves other purposes that might be valuable? And so really kind of trying to look at this as an opportunity rather than as a required compliance heavy lift, but to look at it as an opportunity to know more about our company, to know more about our consumers, to know about what information we have, where we have it, and how we're using it, has been one of the big selling points along the way, and in having those conversations to get the green light and the backing of our senior leaders has been really helpful. I would say the other part of this too is that it's always nice when you have the, hey, it's the right thing to do, sort of on your side, and in this case this felt like a very easy, this is just the right thing to do. It's the right way to treat our customers. We're not afraid of sharing the information that we have with them. We're not doing anything untoward that we would be afraid of having publicized in a surprising way. And so at its core, knowing that we think customers want to do business with us and are sharing the information with us voluntarily and for the right reasons, it really helped along the way. And then the other part of it I would add is that we were very cautious to make sure that if there were any decisions that we felt we needed to make along the way that might restrict our use of information or our ability to keep information, that we were really having a lot of conversations about what the impact of that might be for us, both in the short term and in the long term. And not to get too weedy, but one of the areas for us that we have spent a lot of time and continue to spend a lot of time with is around this idea of deletion or anonymization of data, particularly because we have a lot of actuarial needs and requirements, and being such a long-term company, our actuarial needs and our records go back very, very far, and we actually refer back to that information for a long period of time. And so the idea that we would take the position that we would just be randomly deleting information, not randomly, but upon request, deleting individual information out of those databases was a huge concern to that very real business need for us. And so we've been having a lot of continued conversations to say, how can we both be compliant with the regulations, meet our consumers' requests and expectations, and do the right thing by the business?
Yeah, those are great. Those are great questions. Great questions. Okay, thanks so much, Patricia. That was excellent. So, Laura, let's turn to you and hear about your experience in taking this on within ARM.
Yeah, great. Hello, everyone. I'm Privacy Counsel at ARM, and our situation is a little bit different than Patricia's in that our parent company is a UK-based company. So we went through a GDPR implementation, and the slide that I have up really is just a workflow that we've adapted for data subject access requests and sort of tweaked it to apply to consumer requests for California. Now, just to step back a little bit, having gone through the whole GDPR exercise, a big heavy lift in that was data inventory and data mapping. So finding out where the data is, who owns it, and who to involve in the request. So certainly the GPO, which is the Global Privacy Office, our marketing team, individuals in the business unit, IT, and our data management team are involved in, collecting and, disseminating information that we then provide back for GDPR requests, which we presume is going to be how it works with CCPA, although we'll see how we work with that. I think another difference between ARM and Pacific Life is that ARM is not a B2C primarily. We sit in the middle, and maybe I'm misstating Patricia's or Pacific Life's position there in the marketplace, but just to be clear, we deal mostly with partners or exclusively with partners. So individual contact with consumers or their data is pretty limited, although I will say that on our IoT business side, we're starting to collect some consumer information from end users. So for example, device IDs such as telephone IDs or Mac IDs, for example. Do we have that information in combination with other information where we could identify the other person? In some instances we do. So we're working.
Hey, Laura, I hate to interrupt for a second. We just got a request. Is it possible for you to move just a little closer to the phone? I got somebody indicating that it's a little difficult to hear. I don't know what your setup is there. Okay,
hi.
Great.
Do I come in better now?
That sounds better, yes.
Okay, so apologies. So we do anonymize for GDPR purposes. De-identification under CCPA is probably another route that we'll look at. But the complexity that we also face is the fact that we do have this parent company situation with the UK, and how do we marry up GDPR with CCPA? So some of the unknowns, for example, looking for guidance from the AG, really we're just following what we've done for GDPR in hopes that it aligns closely enough that we won't have to do too much unwinding of processes. So where we can, we're mimicking GDPR across the company. So I'll just stop there. There's a lot of information, but I think there's a question actually from one of the panelists that asked about structured data and unstructured data. And for our purposes, we look at all data just because of GDPR. But as I said in the slide here, things that are out of scope are handwritten notes, Yammer, Skype, and chat Slack.
Yeah, and I'll add to that too. I mean, I think the challenge that we've seen, and to Lara's good point, if you've got a good GDPR program, and if you applied a lot of the GDPR program to U.S. operations or operations that deal with California consumers, great time to try to leverage that and bring things together in a consistent way. I think one of the challenges we've seen coming out of GDPR is exactly this point, which is somebody's coming in with an access request and they're using it not just to actually get access to whatever's in the structured application, but it's almost a pre-litigation discovery technique, right, to get as much information as they can. And there's been challenges in the UK and other places in dealing with these types of access requests and really trying to establish some reasonableness. There are some general, I would say CCPA is less helpful on this than, well, actually, this is antiquated. Prior European law, prior to GDPR, used to be that there were a number of exceptions that could be there. In fact, if you look at the Privacy Shield rules, for example, there's exceptions in terms of level of burden, et cetera. CCPA does have some general exceptions in terms of, manifestly unfounded or other types of considerations to be brought into it. But and certainly, if you've got a privilege issue, you're probably going to say that's an exception, et cetera. If there's any kind of problem with legal compliance with the federal law, if you actually are providing data, then you can be leveraging that. But it can get pretty sticky, I think, at the end of it all. I was going to ask you, Lara, one question, which is, so when it comes, say, like a place where there's a fairly significant, at least on the surface, delta is between sort of the exceptions to deletion and right to be forgotten under GDPR versus how the exceptions are framed for deletion under CCPA. And one way a company could handle that complexity is to just have an internal procedure that says we'll delete in accordance with applicable law. So the nice thing about that, very elegant, right? Just so then we're going to do it in accordance with applicable law. The other would be to try to write some procedure down that tries to capture the essence of what the exceptions are, right? And then be applying an internal company procedure. And then I'd say the most mature, which I haven't seen yet, but that doesn't mean it doesn't exist somewhere, is somebody who actually maps it out to the standard operating procedure level where they know exactly what they're going to do when they get that deletion request, and they know exactly where they're going to go and exactly, what the message back is going to be. And I just wonder, how deep have you guys gotten into those different layers of how to deal with some of the differences in the standards?
So what we've done is we've actually started working on separating out and having a different workflow. So we've implemented a couple of platforms to work with GDPR requests. So we actually will have a separate workflow and platform usage for CCPA requests. So when we go into that, we know that it'll be either a California consumer who's clicked on the California consumer link, and that'll be specific to them, and then it's someone requesting under GDPR. And that'll be actually in our privacy statement. So I think somebody had asked, are we amending our GDPR or doing a separate California addendum? And what we're doing is we have a general privacy statement, and in that we're separating out California, just like we separate, if you are in Europe, you have these certain rights. If you're in California, you have these rights. That seems probably a little bit difficult route to take, considering all the different laws that are coming into play. But for now, that's the path we're taking.
Yeah, that's a really interesting point, and I don't know if Patricia, this impacts you as well. But I mean, that's Lara, you're getting right at. Gee, there's this new California law. Should we parse and really only be providing these rights and focusing on California, maybe even going the extra mile and, surfacing the do not sell link if the IP address is coming from California, and doing some other things to kind of even limit the notices to California residents? Or do we say gee, we know that data breach spread like wildfire. You know, California adopted in 2003 a data breach law, and now every state has one. So should we just kind of deal with everybody all at once across the U.S. and just offer these rights more broadly? Laura, was I just hearing you that ARM decided out of the box that it's going to be much like it confers rights on Europeans when it's GDPR, it'll confer rights on Californians, but not necessarily go broader? Did I hear that was kind of your initial resolution?
That's correct.
Yeah, yeah, and then Patricia, I don't know how did Pacific Life come out on that?
Yeah, so it's a really good example of how this is super challenging in real life, because we also have GLBA notice requirements in the United States from a financial services perspective. And so it's one thing for us, and one of the things we're still struggling with is putting out a CCPA or California resident attachment or addendum or something else along those lines that's specific to California. It's hard to go holistic now, because we know that there are multiple other states who we believe are going to be acting in this capacity. So in addition to having GDPR, GLBA, and CCPA, now do we also have 10 other states that we point to, and how do we do that in a way that doesn't create confusion, but also doesn't make us prone to error in our actual implementation of the rights that we're providing. And so we like the idea of being more global and holistic in those notice requirements, but the practicality is we may be forced into having state-specific and country-specific or at least region-specific notices. So I think that's still a TBD for us in terms of exactly what that's going to look like, but those are some of the issues we're struggling with.
Yeah, absolutely. No, that's great. And I think it's a follow-on question here. There's a lot of good questions coming in, which is great. Please keep the questions coming. We will, though, I think, end at the top of the hour, so in just a few minutes, but I think there'll be a way to follow up if somebody's asked a question elsewhere. And the question is, how would you go ahead and de-scope handwritten notes, Yammer, Skype, and chat Slack, from, say, an access request? And Laura, I'll let you answer that. But before I even do that, I mean, what I think the reality is that and we've seen this over the years with European privacy rules, is there's kind of two varieties of people who are coming to exercise these rights. One bucket, and of course, two buckets of people, obviously I'm generalizing, but anyway, in general, there are some people who come to you and they actually want access because they've just moved their home address and they want to see what you have on file for their home address and they want to update it, or, there's some kind of business transactional purpose that they want to do it, or maybe they're even just coming to you saying, I want access to my data, or I want you to delete my data. But really what they're saying is, I don't want to hear from you for marketing anymore, right? So I think a big part of the challenge for companies is to make sure that intake process, like what Patricia was saying, one-stop shop, it's going to be organized, whatever. The intake process, to really be listening carefully for what the person wants, is going to be critical, so that you're addressing what they really want, because they won't know how to frame it in a privacy perspective. They just will say, I want you to delete, and what that means is they want you not to market, and guess what? If they really don't want to hear from you for marketing, you have to keep their email address to suppress any further marketing to them. So anyway, so you need to effectuate, what it is they're coming to. The other variety is the group that would be using this for pre-litigation discovery. And those people, it's very difficult to have a single playbook for how you're going to, manage this. And so if you do have one of those types of requests on your hands, you may indeed need to dip into and think about, gee, where do we have other communications stored through other communications channels, unstructured, et cetera? Where are we going to draw the line? How are we going to do it? And there's not really a crystallized, certainly no regulatory precise answer yet for how to map that. So, Laura, I just talked for a long time. Do you want to add anything to that about handwritten notes, Yammer, Skype? What do you think?
Yeah, so I think for us it was just a matter of, the amount of resource it would take to go into those areas and search, because there certainly are a lot of areas where you could have all kinds of communications written down that would be you know, the requester would be entitled to, right? I mean, I think one thing, and this is tough balancing, is that under GDPR, you can't sort of limit the right to the information, although having those de-scoped items really does, right? So I think that's one thing, is the resource, but then also, you know, people put things in Yammer that maybe they shouldn't. And if you're dealing with someone who's doing sort of a pre-litigation hunt, if you will, especially a disgruntled employee, what have you, certainly that adds to it. You know, if you have some kind of inkling, you might want to put that sort of on a litigation hold and, you know, have that under privilege, but, you know, it certainly makes it difficult. But mostly, you know, there's this whole idea of, you know, do you have the resource to produce every single thing? And sometimes it just becomes manifestly impossible. You know, we get information requests that ask for metadata, for example. So.
Yeah, great, absolutely. Okay, great. Well, I see we're at the top of the hour. I don't know, Chelsea, is there any wrap-up comments that you need, or how do we close?
Just like that. Thanks so much, Brian. And I want to remind everyone that we did record today's session, and we will be following up with you. That will include an email that will have both this PowerPoint presentation as well as the recording. So stay tuned for that. And I'd like to thank both Laura, Patricia, as well as Brian for leading a great discussion today. And we hope everyone has a wonderful rest of your day.
Thank you.
Thanks,
everybody.